So my name's Ed Rimmel. I'm a partner in the commercial team at VWV. A couple of housekeeping things I've been asked to mention before we start. This recording or this session is being recorded, so that you're aware. It's going to be circulated to, I think, everybody that signed up to the session in a few days' time. There is a sort of Q&A box, so if you have any questions as we go through, please do pop them into the Q&A box. I'll try to keep an eye on it and answer questions as we go along, or save them up to the end if that makes more sense. So I'm going to be talking about what we call contracting tips for charities. So I'm a partner in the commercial team, and I spend most of my time advising clients, and particularly charity clients, on a whole range of contractual matters, whether that's negotiating contracts, putting them in place at the outset, whether it's on how you go about sort of managing your relationship with your contract counterparties through the contract life. And I also get involved on bringing those arrangements to an end and sort of early stages of disputes with contract counterparties. Much of my advice is with charities, so we have a sort of sense for the kinds of issues that that most charities wrestle with when they're looking at their contract terms. And I think whilst we'd like to think that every time a contract comes across your desk, the first thing you do is you pick up the phone to your friendly VWV contracts lawyer and ask them to have a look. The reality is that doesn't happen, and that doesn't happen for very good reason. It's often just not merited by perhaps contract value, contract type, and you're left having to wrestle with the challenges in those contracts yourself. So the purpose of this session really is to try to equip you with some of the thought processes that we go through, that I go through when I'm asked to look at a contract for one of our charity clients, recognizing that actually if you get a relatively small proportion of the things right, and if you focus on some really key issues, that probably fixes the vast majority of the sorts of challenges that you might have as you run along with the process of managing the contract. So we're going to focus on some of these key points. I should say that this is a session really that's intended for, I guess, kind of contract managers, procurement managers, non-lawyers. So we'll try to keep it, you're not going to hear me mention any cases. I don't think I'm going to mention any statutes. So we're going to try to keep it fairly practical in nature rather than too legal. So with that said, what are we going to be talking about? Well, I'll touch on some of what we might think of as the kind of the real basics. So the kind of contract law 101, the stuff that sort of I might learn right at the very beginning of law school. So what a contract is and how you go about entering into one. It sounds daft, but actually there are some important sort of takeaways there, some pitfalls that you can fall into if you don't kind of keep your eyes open for some of them. We'll talk about the importance of clarity in contracts. It's a bit of a bugbear of mine, but so often the things that go wrong in contracts are a function of the drafting just not being clear. And whilst we're sort of trained and we spend lots of time thinking deeply about that, actually a lot of it is just English comprehension. So being really, really clear about what you're saying and why you're saying it. So we'll have a think about clarity. We'll have a look at what we call some easy wins and common questions. So things that, I guess, from my perspective, I often get called by clients about and asked, how do I fix this, or what should I do in this scenario? So what can you do at the beginning of the contracting process to avoid having to pick up the phone to your friendly lawyer in a couple of years' time and say, how do I get out of this? And then we'll look at some contract management issues and tips. You've got a contract in place, don't put it in the drawer. It's a kind of live thing. You've got lots of rights for yourself that you've negotiated with the other side. They're there for a purpose. Use them. Think about how you best use them, how you best get value from the contract that you've spent that time negotiating and putting in place. So they're the sort of four areas we'll touch on. I think we've got an hour. This is an abbreviated version of a much longer session, of a 3-hour session. So consider yourselves lucky that you're just in the hour-long version, but it does mean that we'll skip through some of it relatively quickly. I'll aim to finish at about 10 to 11, give time for any sort of further questions, but let's get on with the first section. So the real basics: what is a contract? Do you have a contract in place? and whose terms should you contract on. So what's a contract, and why is getting it right important? It sounds obvious, but it's a set of rights and obligations that you owe to the contract counterparty and that they owe to you. And the difference between a contract and just a sort of a discussion of aspiration as to what you might do is that those rights and obligations are enforceable by each other, against each other. When you think about what goes into the contract, you might focus, and I'd encourage you to focus on some of the sort of detail of the services that are being provided and so on, and who's paying who what. But lots of the nuts and bolts of the contract are kind of an allocation of risk between the parties. So if it doesn't quite go as we'd all planned, who bears the risk for that? If there's some awful intervening event, COVID is a really good sort of recent example, but if something happens that we didn't expect, where does the risk for that sit? How much risk are you prepared to take, and so on? So you can break the contract down into the sort of practical stuff, so the who's doing what, and the risk allocation stuff. And I'd say they're both equally important. I think the practical stuff is often overlooked by lawyers, if I'm honest, and I think the risk allocation stuff can sometimes be overlooked by sort of commercial folks, and they're both important to get right. Contracts aren't just important though, because they're a bunch of enforceable rights. The reality is, for the vast majority of contracts that you'll be looking at, and particularly for those that perhaps don't meet the sort of external lawyer or in-house legal threshold, the purpose they serve is more one of expectation management. And by that I mean they're probably not of a value that's going to warrant suing the other side if they don't do what they promise to do. But they are of value in terms of framing the discussion that you have with the other side as the life of the contract runs on. That's what the expectations are, what you should each be doing. You might never end up in court on it, but it's a really useful thing to have. It gives you a bit of leverage in discussion if you think that the relationship isn't quite working out as you'd hoped. And finally, why is it important? Well, it's important for all organisations, frankly, but particularly for charities as a matter of good governance. And in terms of the sort of role of your trustees and custodians, charity assets, and so on, a contract frames your liability, and it frames your sort of the extent of the liability of your other, of the contract counterparty. So having a sensible frame around your liability is a really important protection for your charity. Being really clear as to what sort of services you're getting and to what standard is a really important part of the sort of good governance of your charity. So having been through that process of thought carefully about what's in the terms and negotiated them to get them to a position that you're comfortable with, and if a charity lawyer were here, I'm sure he'd be telling us that it's a really helpful thing to be able to demonstrate in terms of your trustees and your sort of management structure going through the right sorts of governance processes. Is there a contract in place? That sounds really obvious in some ways, and it often is. You've had a long negotiation, you're happy with the terms, you have a grand meeting, you all sign it, you have a glass of champagne, everybody's happy, for a contract that you can waive. That's really obvious. It's often not that obvious though, and often the sort of practical reality of negotiation and the imperative to start service delivery means that actually by the time service delivery starts, perhaps you don't have a signed contract in place. And once service delivery is started, the reality very often is that finalising the contract then takes a bit of a back seat. So it's not uncommon that you'll have a relationship in place where everybody's behaving as though there's a contract there. You're perhaps paying for a service and the service is being performed, but you haven't got a final form of contract. You certainly haven't got it signed. Perhaps there are a few things that hadn't yet been finalised in it. You don't quite know what the terms are. Do you have an enforceable contract in that scenario? Quite probably yes. What are the terms of that contractual relationship? It's a bit less clear than where you have a signed contract. The negotiated document will be a good starting point in terms of indicating what those terms are, but you have a lack of clarity to it. So you can certainly give rise to a contractual relationship in circumstances where you don't expect it to, and at the sort of far extreme of that, you can give rise to a contractual relationship far before you even get to negotiating contract terms. You can give rise to it through an exchange of emails. There was this sort of famous Mike Ashley down the pub with his mates agreeing some sort of crazy share-related corporate deal. That got to court. It was argued in court as to whether that conversation after a few pints was enough to give rise to a contract. It didn't there in that scenario, but merely the fact that it got to court indicates and suggests that it certainly was capable of potentially in slightly different circumstances. So be really careful as to the kinds of commitments that you're making, and do be aware that your behavior, things you say, the exchange of emails that you make are capable of creating those sorts of obligations. And the things that you're looking for in terms of whether a contractual relationship has been created, or whether one of you has offered to do something, the other has accepted that offer to do something. There's some value passing, so frankly, at its base, you're each getting on and doing it. There's some money being paid and there's a service being performed. And the harder one sometimes to demonstrate is an intention to create legal relations. Now, that will often be a function of the circumstances, but don't assume that just because you don't have a piece of paper with your signature on, that you don't have an intent to create legal relations, or that can't be inferred into your relationship. Whose terms should you contract on? Again, sometimes obvious, but not always. A few takeaways here, I think. Don't assume that because your supplier has provided you with their set of standard terms that they're either reasonable. I think that's probably a safe bet. They're unlikely to be from your perspective, but neither should you assume that they're fit for purpose. Far too often we look at contract terms that come from suppliers, particularly smaller suppliers, where they've dug something off the internet. It's entirely standard. There's nothing bespoke about their service, and it just doesn't really work for what they're doing. So don't assume that because you've gone out requesting somebody to provide a service to you, that the contract terms they've got, that they're giving you a fit for purpose. They're often not. So what should you do then? Well, for some organizations, it could be really useful to have a set of standard purchase terms. So we're talking here in terms of sort of charities entering into service contracts, but certainly where you're entering into fundraising type agreements or commercial participation agreements, you should absolutely have a set of standard terms that you use. But even for purchase of services and purchase of goods, it can be helpful to have a sort of standard set of T's and C's that you can put out to your supplier and try to get those in place at the beginning of the relationship, comfortable in the knowledge that they're reasonable and sensible from your perspective. If you've got bespoke activities around commercial participation, 100% you should have a standard set of terms that you've tested and you're happy with. Where you get standard terms back from the other side, test them and think about them, what's important in that relationship. If they're a software provider or some kind of platform provider, are they looking after your data? If they're looking after your data, have they got the right analysis as to what the data controller, data processor relationship is? Are they reasonable? Are they balanced, and so on? And certainly sometimes where you're going out for very bespoke services, but where you have a kind of competitive process that you're running, you have some competitive tension in the process. It can be a good idea if they're high enough value services to go out with your own set of terms. So perhaps ask lawyers or your in-house team to develop a set of terms for you that are bespoke to that requirement, and then you're on the front foot in those discussions with your service provider, rather than being on the back foot and having to accept what they propose to you. So section 2 on the importance of clarity. We'll have a think about where things most typically go wrong, and I'd say probably 50% of the sort of issues that we see in terms of potential disputes would almost always would have been resolved through clearer drafting in the contract terms. So we'll look at some drafting basics, and we'll have a think about two areas which I think are often overlooked. We'll have a look at service scope, and we'll have a look at payment obligations. And why do I say they're often overlooked? Well, they're often overlooked, I think, because when you think of a contract, you often think of the sort of the nuts and bolts that sit at the front of the contract. So you think about the termination provision and the liability provision, and perhaps some boilerplate stuff that goes at the end, and force majeure that we're all thinking about now that we didn't think about 5 years ago. We often forget, I think, and I think we're all guilty of this, the really important bit of the contract, which is who's doing what and who's paying for it. And I think there's kind of an assumption that, well, that's less critical. We don't really need to get that so right, provided the force majeure bit is right and so on. I'd say it's absolutely the other way around for contracts that are never going to make it to court, particularly, as I say, kind of lower value contracts. The most important thing in managing your relationship is clarity as to who's doing what and who's paying what for it. So we'll have a quick look at service scope and payments obligations and how you can sort of help with that clarity to avoid those arguments down the line. So where do things go wrong with the lack of clarity? Well, it kind of crops up in a few different guises. I think there's often a bit, or it can lead to a bit of a misalignment of understanding between the parties as to how the arrangement should work. And you'd be surprised how often two people can read the same sentence and take something different away from it, in terms of sort of what's required to be done, how it's required to be done. So where you're putting a contract together, and there's a really important bit in there, whether it's around the service scope, whether it's around the payment terms and how you go about calculating what you're paying, it's always worth, I'd say, getting somebody else to take a look at what you've written and tell you what they understand from it. And you'd be surprised how often they understand something a little bit different. And where you have two parties who are sort of in some way naturally in conflict on payment terms, one is obviously intending to be paid as much as they can, and the other one will spare as little, you're bound to read it in the way that is more favourable to you. And that kind of misalignment of expectation can come back to bite you a year or so down the line. And what I'd see, we do hear sometimes people saying, well, you can make an argument that it's read this way, and I think I've got the better argument, so therefore I'm happy with the drafting in that way. I think what I'd say is, if you can avoid, if you have a common understanding at the outset of the contract, even if it's a common understanding which isn't quite the one that you'd have preferred, I'd rather have that common understanding now than have a falling out a year down the line when you're reliant on a service. You're sort of exposed to the whims of how a court might find, and at that point you've sort of had a falling out. Not reading and understanding the terms as kind of a part of the same, sort of the other side of the same coin, I think. I don't think I've ever read my Apple terms, and I suspect I never will. But for services where you are really reliant on them and they're an important part of your business, read and understand what's in there, even if you can never change them. Understand what risks it imposes on you, and have a think about how you can best go about mitigating those risks. So we'll have a look at notices in a little bit, but if it requires you to do something in a particular way to bring it to an end, to bring the contract to an end, understanding that mechanism equips you to be able to manage it when you get into the sort of operation of the contract. So read and understand the terms and try and iron out any ambiguity. We've had a question in the Q&A. So should a contract be in plain English, or would this remove many essential, often legal terminology? 100% a contract should be in plain English. There are some legal phrases and nuances which I think do have a particular meaning and which it's important to understand. But I think for all contracts, the most important is that they're there to help you manage the relationship. And if you can clearly express what it is that you mean, and you've expressed that in a way that is understood equally by both sides, that will avoid the vast majority of disputes, and you're never going to be in a worse position, I think, by using plain English drafting. I think be aware of particular legal terminology that might crop up. Things around, time of the essence is one that always kind of crops up and has a particular legal meaning. But you can say that in plain English. You can say what you mean by time of the essence in plain English. Same with things like sort of indemnities have a particular meaning, but again, you can say it in plain English, or you can use that terminology in a way which is really clearly understood. So the clearer the better, I'd say. Avoid legal terminology unless it's absolutely essential. So some basics around drafting the contract. Certainly you have the opportunity to draft it when you're reviewing sort of the other side's terms, or you're putting your own document together. Be comprehensive and logical and methodical. So if something isn't in the contract, if the contract doesn't say something, if it doesn't describe a particular obligation on the other party, if it doesn't describe a service that they're going to provide, then it's very difficult to create and to imply in an obligation on the other party to do that thing. So if there's something you're relying on them doing, be comprehensive about it and explain it in full and in detail in a kind of logical and methodical way. Think about the sort of story of the contract. So just so often when I'm sort of talking with folks here who are sort of starting out the journey of understanding and sort of how they go about putting a contract together from scratch, the bit at the front that describes has the sort of what we call the recitals, so the kind of background bit that describes what's going on is really, really important, because it sets the scene and it gets straight in your head who the parties are, what they're doing, why they're doing it, and so on. And following that sort of approach throughout the contract in a kind of clear and methodical way. So who's doing what and when, what are the parties going to do if it goes wrong, what are the consequences of things going wrong, how do you go about bringing it to an end. That sort of logical and comprehensive process can be a sort of really important part of drafting it in a plain English and understandable way, but also making sure that you've picked up all the stuff that's likely to be important during the life of the contract. As I say, leave nothing to the imagination. If it's not in the contract, it's probably not a right that you've got. There are some exceptions to that, but assume that if it's not in the contract terms, you can't rely on it. We'll look at that in the context of service scope later. So particularly if you've gone out to tender, you've invited bidders to provide you with a proposal for what they'll do. They'll probably promise all these wonderful things in their tender response about sort of service times and turnaround times and the quality of performance and so on. If those promises don't make it into the contract, then good luck enforcing those promises against the bidder when they don't do all the stuff that they'd promised they'd do. So importing those pre-contractual promises into the contract in a way that you can then rely on is a really important step that you should be going through. English comprehension, we talked about the clarity of drafting is kind of really clear what you mean, but focus on what's important. So we often fall into the trap of thinking, you know, there's been lots of, we'll talk about data protection, don't we? And data protection is an important thing to get right. Do you need to include really comprehensive, complicated data protection clause in every contract? No, you don't. If the contract isn't really dealing with the processing and handling and managing of personal data, don't focus on the data protection bits. If that contract has a load of really important IP that's being developed by the other party for you, focus on the intellectual property bits. Think about what the services are and what's important in that context, and focus your limited energies on the bits that will get most value for you. So it's don't assume that everything is equal in every contract. It'll be different depending on the circumstances of the services. So the service scope, we quite often look at a contract here which has come across from a service provider, and it has all of the sort of front end stuff, all of the term and termination and liabilities and force majeure and all the sort of stuff that we think of as being the legal contract provisions. And you get to the service scope and it's just a one-liner and it says access to a SaaS platform or delivery of a sort of report, and it doesn't give any detail about what that platform involves, how regularly they might take it down for maintenance, what sort of response times you might expect to see where you have an issue with it. For the report, it doesn't say, you know, what they're going to be assessing, how they're going to be putting it together for you, sort of timeframes of delivery and so on. The really important nuts and bolts of the contract are often missing, and it can be very frustrating when that comes from a service provider saying, what are you actually committing to here? So focus on the service scope. I'd say it's almost the first thing you should do when you pick up a contract is look at what the services are and are they adequately described for you. and don't just look at what they're committing to do, look at the standards to which they're committing to do it. So if they're going to, and sort of platform uptime might be a good example in the context of a SaaS contract. Sort of in the context of a report, there might be particular things that you can expect of them in terms of you being able to tell whether that report has been written to the sort of standard and has covered the areas that you expect it to. So describe those standards and think about what levers you should be able to pull if those standards aren't met. Are you able to sort of at the extreme end bring the contract to an end, but you don't want to do that almost certainly, so should there be perhaps service credits? Should there be deductions to their payment rights if they don't quite perform the contract to the right standard? Or if it's a long-term relationship, should you be able to deduct monthly payments against sort of particular failings, and can you allocate values to the gravity of those failings that you might be able to impose against them? So think about the services being provided, the standards to which they're being provided, and the levers that you want to pull if they're not provided to those standards. Payments obligations, again, almost as important, or probably as important as the service scope. Is it really clear what you're going to have to pay and when you're going to have to pay it? In some cases it is. Perhaps it's a lump sum payment payable up front. I'd think carefully about that if you're agreeing to that, because once the money is in your service provider's pocket, their motivation and incentive to do a really good job for you has probably diminished somewhat. So have a think about timing of payments and sort of when you're expecting to part with your money. But very often it's not just the lump sum payments up front or in staged, it might be against milestones. So think about how you define those milestones. Are you in control of them? Do they have to do something to your satisfaction, or do they just have to do that thing and tick a box? I'd say the more control you have over whether those milestones have been met, or the more input you have, the better. And the calculation process isn't always sort of simple maths. So we've certainly seen a good example where we've had a payment mechanism which has been defined by reference to the number of units sold, and the price dropped once a certain number of units had been hit. But the drafting was a bit unclear as to whether once that number of units had been hit, the price dropped for the excess units, for the units above 100,000 that have been sold, or whether it had the effect of dropping the price for all of the units. And it sounds as though, I mean, that sounds like a sort of silly example, but it led to an awful lot of work for our litigation team. It was quite a high value contract. It led to a lot of work for our litigators arguing the toss over something which frankly should have been more clearly drafted at the outset, because everybody probably had a common understanding at the beginning of the contract. They just didn't say it very well, and that led to a dispute down the line. So really good example of give it to somebody else to have a look at. What do they read? What do they understand from that clause? And does that understanding reflect what you want it to achieve? We've had a comment in the questions mentioning that sort of one of the audience always uses a drawdown purchase order for contracts with milestones. I think that can be quite sensible. I guess the point is, at what point do those payment obligations kick in? And I suspect your purchase order needs to make clear that sort of as the PO is issued, what the sort of payment will be made against and what the sort of particular milestone is. But it comes back to the point that I made earlier about having control over when those payment obligations arise, whether that's through the issue of a PO or whether it's through the sort of the drafting mechanic for description of the purchase obligation in the contract. So some easy wins and common questions. We'll have a bit of a look at term and termination. Again, they sound obvious, but it's probably the most frequently asked question that I have in terms of fixing contracts as they run along. We'll have a bit of a think about liability and how you frame your liability and how you might think about your supplier's liability. And then we'll skip through some provisions which are specific to the context of the contract, as I sort of talked about earlier. So term and termination. I think probably the the one single thing that I get most calls from charity clients about is, and the conversation usually goes like this: I've got a contract in place. It's usually with a kind of relationship, a kind of contract that doesn't have much in the way of kind of day-to-day relationship between the service provider and the customer. So it's often something like a software as a service contract, or I don't know, silly, a photocopy license or something silly like that. But the conversation usually goes, I've got a contract in place. It was a 3-year contract. We're coming up to the end of 3 years, and my provider has said that this is going to run on for another 3 years. Can I get out of it? And you often look at the contract and you see that it has a horrible provision in there which says there's a 3-year contract, and it'll come to the end at the end of 3 years, provided you've given at least 3 months notice before the end of that 3-year period. And if you haven't, it automatically rolls on for another 3 years. And it's very difficult, if you don't comply with that mechanism, to get out of it. You're tied in almost always to that extension. It's not like consumer contracts where it's a bit harder to impose that sort of automatic long-term extension on a consumer. In a business-to-business contract, as you'll be entering into, you're kind of locked in broadly to what the terms say. There are some exceptions, but you should assume that what the terms say you'll be locked into. I'd always advise against including that sort of automatic renewal mechanism in a contract if you possibly can. You can't always get it out, and if you can't get it out, you really need to make sure that you diarise those timeframes so that you can take a decision after 2.5 years as to whether you're going to serve notice to terminate and get out of the contract. Because usually for those non-relationship driven contracts, you'll get fairly short shrift from the other side when you go to them asking to bring it to an end early. I had a great example yesterday, actually, an unusual one, where it was the service provider trying to get out of their contract, and they'd gone about it wrong, and they'd served notice in the wrong way. And our client, a charity, was able to lock the service provider into the contract for another year because they hadn't complied with their own term. So that kind of felt quite nice. Boot was on the other foot, but usually it's our charity clients who are on the wrong end of that sort of provision. So look out for those. The other sorts of termination mechanisms, so there are 2 broad termination mechanisms. I'll talk about termination for breach first. You'll often see in contract terms, and you have certain rights sort of under kind of common law as well to bring a contract to an end if the other party terminates it badly enough. And that's often phrased as you have a right to terminate if the other party is in material breach of the contract. And that sounds fine. That sounds great. The other party doesn't do what you're expecting them to do, and therefore you can bring it to an end. The reality, though, is if you pick up the phone to us or to another lawyer and say they haven't done what they're expecting, can I terminate for material breach? The answer will often be it's probably not that straightforward. It's always a bit of a punt to terminate for material breach. It's very rarely really clear cut that you're right, so that the breach is serious enough to allow you to terminate. And the risk for you of terminating for material breach where you don't have the right to do that is that it's you that puts yourself in breach of contract, and you're then exposed to the risk of a claim from the other party against you. So very often the advice you'll get where things aren't quite going right and you want to bring it to an end is there'll be a bit of sucking of teeth on my part, probably. And the advice will be, well, you can do that, but it's a bit of a risk. Which is why, so my advice usually in most contracts is if you can get yourself a break right in there, it can be a really useful tool, particularly for the sort of relatively low value contracts that just will kind of bimble along for a few years. Perhaps the service provider isn't putting lots of investments up front into the relationship, so they're not standing to lose a whole load of money if you bring it to an end early. Having that break right can be a really useful way where the relationship just isn't working and the services just aren't being performed in the way that you hope them to, but you can't quite demonstrate material breach. It's a really useful way to allow you to draw a line under the contract and walk away from it. Now, you won't always find that accepted, but it's certainly worth looking at as to whether you can get that sort of right drafted into your contract, because it can be a very helpful one. Liability. So I guess the key takeaways here for you are sort of what will you and the other side be liable for, and for how much would you be on the hook. The what, there's quite a lot of, when you talk about plain English, the drafting that goes around sort of liability clauses and exclusions. That's probably the area that's least likely to be in plain English. There's often some sort of standard text in there that has been used 100 times and is all a bit alien. I guess what I'd say is think really hard about the stuff that you definitely do want the other side to be on the hook for. So if they perform the service badly, what are the sorts of things, what are the sorts of losses that you might suffer, and point to those as specific things that you'd want to be able to recover if they do those things badly. Other specific things that you'd never want them to be able to recover from you, and sort of point to those if you can. So specific inclusions can be a really useful thing, and it helps you and the other side to focus on the sort of consequences if things go wrong. And a cap on liability, in as far as you can get it for yourself, is obviously a very helpful thing. Where you're the service recipient, it's probably a bit less important, because there may be a good deal less that you're doing, and therefore a good deal less that you can be liable for. In terms of caps on the other party's liability, do have a think about whether what they're suggesting is reasonable and appropriate or not. And I'll give an example. Give the example of us in your instruction of us in your engagement letter with us, which gives a kind of contractual basis for us to perform our services. We do have a cap on liability, but it certainly won't be set at the amount of the fees that you pay us to perform the services for you. It'll be set at some very material multiple of that, in the sort of millions of pounds. And the reason we do that is because we're comfortable that we have insurance that stands behind it and backs up our risk. There's no reason really why, for lots of other service providers, provided it's a kind of liability that they should be able to insure, that their liability shouldn't also be sort of a similar scale. That won't always be appropriate, but it very often is. So in the standard terms that you're seeing from your service providers, where they sort of take the lazy default approach, which is to say our liability will never be more than the amount that you've paid us, you need to think carefully about two things. One, will that cover our loss if they do a really bad job? So, and a good example might be a sort of platform provider hosting a load of data for you. They suffer a data breach. What sorts of things might you be on the hook for? Potentially rather a lot. Is it likely to be to a value of more than you've paid for the use of their platform for a year? Almost certainly. Should they be insured for that kind of exposure? Yes. So they shouldn't be capping their exposure to you at the value of the annual contract value. So have a think about what might you lose. Should they have insurance for it? And if they have insurance and you're likely to lose sort of significantly, think about setting your cap at a level which gives you access to their insurance if you need it. We've had a question, silly question, but it's not. What's the difference between liability and an indemnity? So there's two different. I mean, an indemnity is a kind of liability. So liability generally is how much it's an obligation on one party to pay or compensate the other party for something that they've done wrong. So if services are performed badly and it causes you a loss, the other party will have a liability to you to compensate you for that loss. And that's just a normal function of how a contract works, which is you make a promise to do something, you don't do it, and the other party suffers a loss as a result. They have a right to recover that loss from you. An indemnity is a slightly stronger form of that, which is it sort of points to a specific circumstance and says, if this specific thing happens, then I'm going to suffer this specific consequence, and you're going to kind of keep me whole. You're going to compensate me. You're going to indemnify me for that specific consequence. So a good example might be you have the other party's generating some intellectual property content for you, which you're then going to use. And if you use that intellectual property and it turns out that they copied somebody else's IP and therefore you're infringing that other person's IP, you might well look for an indemnity from the person that created that dodgy IP for you to say, in that circumstance, any claim against me from that third party whose IP I've infringed, I'm going to be able to bring that claim against you. And you're not seeking to qualify that right by reference to all the sorts of tests that might be applied under sort of the normal mechanism for calculating compensation for breach. You're saying for this specific circumstance that I've identified and for this specific type of exposure, you'll pay me for that. It kind of creates a payment, just a plain payment obligation on the other party rather than a need to go through a sort of compensation calculation process. I hope that answers that one to a point. So some context specific terms, and this comes back to what's important in the particular contract that you're looking at. Focus on the important stuff. So regulatory compliance, fundraising agreements, commercial participation agreements, you'll want to make sure that they comply with the obligations in the relevant legislation there. So you know, make sure that they do. Safeguarding type provisions. If you're a charity that is involved in the sort of care for young people or vulnerable adults, you want to make sure that certain types of contracts, depending on what's going on, reflect those sorts of regulatory obligations. If IP is a really important bit of the contract, focus on the IP clauses. Who owns the intellectual property? Is it being licensed to you? What happens at the end of the contract term? Do you still have the right to use it? Is it your IP or are you licensing it back? So think about how the sort of IP relationship works. Data protection. I'm no data protection lawyer. As soon as data protection becomes an important thing in a contract that I'm looking at, I'll pick up the phone to one of my colleagues who is a data protection expert. But think about in the context of the service that's being provided, is data a sort of important part of this service? Is it relevant here? Is our personal data being looked after by somebody else? And if it is, I'd recommend that you speak to your DPO or friendly data protection lawyer to make sure that what you've got in the contract is compliant with your obligations under the UK GDPR and the Data Protection Act. And I've mentioned TUPE in there. That's the sort of process by which employees at the beginning of a service might transfer from one party to the other, depending on sort of how much of a service is being transferred and how much of a service is being undertaken. It's relevant in some quite specific contexts. So things like catering outsourcing is a good example where the sort of the workforce of the caterer might flip between the customer and an outsourced provider. But it's important to get right in that context where it does crop up. So if you're unsure about whether a particular contract might attract TUPE type risk, have a chat with your HR team or pick up the phone to me and we can have a chat about whether it might be relevant or not. Finally, so contract management. This is the contract's in place. You've spent lots of time negotiating it. It allocates risk between you and the other side in a way that you're comfortable with. But you put it in a drawer and you never read it again until something goes wrong. And that's a recipe for things to go wrong, I'd say. So we'll have a quick look at using your rights, at managing change as things change during the contract life, and at managing disputes. So using your rights. Very often the first we hear of an issue under a contract or a potential dispute is once it's got so serious and it's got to the point that you're so fed up with the other side's performance that you decide to do something drastic about it. And very often at that stage, it's either too late or you've missed lots of opportunities in the build up to that to be able to get that sort of aggregated picture of all of the other side's failings to allow you to demonstrate a potential possibly material breach or so whatever it is that you're trying to show. So spending time in the small issues as they crop up can be really helpful for two reasons. first, it can stop you ever getting to the really big issue, because those small issues, if sorted out early and fixed and done better, can stop them turning into sort of a major issue down the line, which might cause you to want to take more drastic action. And secondly, if you do spend time on those small issues and it doesn't fix them, and they keep reoccurring, and you get to the point down the line where you do want to take more drastic action, you'll have built up a picture which can then be really helpful when you're trying to demonstrate, as part of a dispute, whether you have a right to exercise your perhaps termination for material breach rights. It can build up that picture of the materiality of the breaches. And if you haven't got that evidence through raising issues formally with the other side, issues not being fixed and so on, it can be really difficult to demonstrate that you've met that threshold. Exercising your rights can be, it sort of sounds trite, but can be really important, particularly because if you don't exercise your rights, then there is a risk that you lose them. So you'll negotiate into your contract terms rights to do certain things, perhaps rights to levy certain payment deductions against sort of poor performance and so on. But if you go year after year and just constantly accepting slightly poorer performance and never turning to the page in the contract that refers to KPIs and service credits and so on, after a time, there comes an argument potentially that the other side can make to say, well, we've got so far down the relationship, but you clearly never intended to exercise that right. You've kind of waived it. You don't have that right any longer. So you can find that through the course of dealings and actions, you don't have the right that you've carefully negotiated at the start of the contract. So understand the rights in the contract that you've given yourself. Use those rights. And if you don't use those rights, think carefully about why you're not using those rights and take a sort of informed decision about whether you're going to use those rights or not. Complying with the formalities is key. And the example I gave earlier, where the service provider tried to terminate the contract, I was called with a charity client yesterday, was unable to terminate the contract because they hadn't complied with the formalities. What do I mean by that? Well, in this scenario, the service provider was required to serve written notice on our client. And when you look at the notice clause, it's very clear what it meant by written notice. It said written notice meant either recorded delivery or first class post. And it was very clear that written notice could not be noticed by email. The service provider had sent what they thought was a notice giving effect to a termination, and they'd sent it by email. And we were able to say, I'm sorry, that was ineffective and therefore it didn't work. So if the contract says to do something in a particular way, you have to do it in that particular way. And if you don't do it in that particular way, you risk not validly exercising that right. So comply with the formalities. You can find things tucked away in parts of the contract that perhaps you weren't expecting them. So read carefully through the contract before you go exercising any rights to see whether there's anything else that you should be doing that you haven't already thought about. And recording your concerns. I mean, that's the point I made about earlier in terms of dealing with issues as they come along. Sort of capture it, keep a record of it. It's helpful, evidentially, if you come to have a dispute. Change management. So what do I mean here? Over the course of a fairly long-term contract, inevitably things do change. Perhaps the services that are being provided might change. A few things might be bolted on to them. Perhaps the price that you're paying might change because you've agreed for something different to be done. All of those changes are changes to the contract terms. And you always need to think about those changes in the same diligent and careful and clear and comprehensive and English comprehension way as you would have thought about them if you were putting that provision into the contract at the outset. So if you are changing the relationship, if you are doing something different, capture it in writing. Make sure both parties understand the same thing by it. File it away somewhere with the copy of the contract that you've put away for safekeeping. Because if you don't do that, you're setting yourself up for a dispute down the line as to, well, what did we mean when we said that? And a really good example of that was around the early days of COVID, where lots of organizations, for really noble reasons, were adjusting the way that they were working in order to reflect and accommodate the sort of completely unexpected and extreme scenario that we're all facing back in 2020. 6 months later, when the dust had settled a little bit and people were looking back and thinking, what have I committed to do differently? How long have I committed to do this for? What did that mean for my payment obligations over the last 6 months? Can I recover for all the extra costs that I've been spending to do this? Very often that hadn't been documented because in the understandable sort of frantic period in early 2020, people just didn't get around to that. Excusable back then, I would say, given the circumstances, less excusable now, where you have a change which you're agreeing and you're just not capturing. So capture it in writing, because you risk paying the consequences later if you don't. And finally, disputes. They do happen, despite the best drafting and the clearest drafting and common understanding. That there will be fallings out. Those fallings out tend to be, as I said, in our experience, around particular things, and they can often be avoided, but they're not always going to be avoided. What you want to avoid when you get to a dispute, if you possibly can, is the expense and the risk that you run in that dispute working its way through to court. And the story from one of our litigation partners who, well, when I first met him about 8 years ago, he told me he'd only been to court once in 14 years. I suspect that's probably now twice in 22. Disputes very often don't get to court. They're very often settled. But having that bulk of evidence that demonstrates your position under the dispute and the rightness of your position can be really useful in that negotiation process and trying to get some leverage to get a better outcome for yourself under the sort of dispute mediation, whatever the dispute resolution process is. I think where a dispute does crop up, and there are a couple of things you should do immediately. I'd say the very first thing you should do is get on the phone to your insurers, for a couple of reasons. Firstly, it may well be that not notifying your insurers early enough has consequences under your insurance policy, whether it invalidates your ability to make a claim under it and so on. Having an early conversation with them puts them on notice that this is happening, and it helps you to avoid the risk of doing anything which might invalidate that policy. Secondly, you may very well find that your insurance has legal expenses insurance in it. Your insurers may well have a view as to who they prefer to manage that litigation or that dispute for you. So you may be able to get your legal expenses covered by having that early conversation with the insurers to do that. So I'd say have a chat with your insurers first. Pick up the phone to your lawyers second, whether that's us or other lawyers that you use or the lawyers the insurers refer you to, just for an early chat as to what sorts of things you should be thinking about, what sorts of evidence might you want to be thinking about gathering, what sort of process should you be thinking about using. I'd say there's not that much lost by an early conversation. There can potentially be quite a lot lost by deferring that conversation for too long. I think that's it in terms of the slides. We've got a question here. Is there any value in having a day or two break between contracts to avoid any concept of a rolling contract? I'd say probably not. I think the concept of rolling contract really is a function of what the contract says. I don't think having a sort of a 2-day window in the middle, all that's likely to do is leave you without sort of reliable service provision for that short period. So in the context of a sort of platform service, a 2-day break leaves you in a bit of a lacuna as to what rights do you have in that period if something doesn't get done in the way that you're expecting it to be done. So I'd say that the more important thing about the rolling, there's nothing wrong with a rolling contract, and quite often you'll have a 3-year contract that says at the end of the 3 years it'll run on unless you give notice on a month or something of that nature. That that's perfectly sensible, perfectly reasonable. Avoid you kind of having a cliff edge. The real risk, higher risk ones are the ones that say after the 3 years, it will automatically extend for a much longer period. And that's much harder. So I'd say a rolling contract isn't automatically something to be avoided, but it's something to be carefully thought about in terms of how long it rolls for and what the processes you have to go through in order to stop it from rolling on. Are there any other questions? We've got a few more minutes before the end. I've run on a bit past 10 to 11. I can't see that there are any other questions. Do type them in if there are. If not, I hope that was useful. If you have any other follow-up questions that you haven't thought about, please do pick up the phone or drop me an email or phone your usual contact at VWV. Very happy to help. Otherwise, I think the questions are now closed. So have a very good rest of your day.